Today's daily list, Your Lordship.
Okay, 6.
Your Lordship, matter may be adjourned, Your Lordship.
On the prayer of Mr.
S. Paul, Your Lordship.
Learned Counsel for the S. Paul, Learned Counsel for the appellant. Read the appeal after a week, only 2 weeks by the MS A. Begum, Learned Additional Public Prosecutor for the respondent state. His present
Oblige, Your Lordship.
has consented to the said prayer. Has consented to the said prayer.
May I please mention for listing? Actually, a case was, I have taken time 1 month for payment of the second installment in Meta bill number 9/20. Already he have paid on 4th August.
Okay, next week.
On Monday, my lord.
Next week.
May I please to mention for the listing of a criminal appeal number, Your Lordship, 445 of 23, Your Lordship.
For
For orders, Your Lordship,
orders.
on 14th, on Wednesday, Your Lordship.
Yes, I do. Did you what I did?
Oblige, madam.
For admission item number 1.
May it please, Your Lordship. Criminal appeal against conviction.
Item number 3.
The learned legal aid counsel for the appellant is found absent today on call. Full stop. MS A. Begum, learned additional public prosecutor for the respondent number 1, state of Assam, is present. Full stop. But when notice were earlier issued to the respondent number 1 at an address within the territorial jurisdiction of Motia Police Station, District Gwalpara. The said notice returned back with a report of the officer in charge, report dated 29/7/2024 of the officer in charge, Motia Police Station, District Gwalpara, that the respondent number 2 could not be found at the. What is that? Yes, madam.
Lordship, paperwork is
Your name?
S. Boshak.
S.
Boshak.
Boshak, learned counsel representing Mr. B. Haldar, learned legal aid counsel for the appellant, and MS A. Begum, learned additional public prosecutor for the respondent number 1, state of Assam. E case it also needed. And 302. As the paper book is ready, office to place the appeal for hearing in the usual course.
Item number 5.
May I please, Your Lordship?
Yes.
This matter has come for consideration for IMA for suspension of sentence, my lord. What has happened, my lord, during this period, my lord, is appellant number 2, my lord. He has undergone some operation, my lord. Medical issues were there, my lord. So we want to bring it on record, my lord, on some medical ground, my lord. Because
That will not be on merit.
yes, we want to take a chance, my lord.
Okay.
Subject to lordship permission, my lord.
Mr. P. Kotoki, learned counsel for the appellant, has submitted that the appellant number two,
To appellant number 2, Rupa Gogoi.
uh, has been suffering from health issues during incarceration, and he wants to bring the relevant documents on record by appropriate pleadings. So he has thus sought listing of the appeal after
After a week, my lord.
after which first of list the appeal after which it will be explained.
Item number 7 to 9.
Arising out of same
Yes, my lord.
judgment.
Same judgment, my lord.
Same judgment. Where is the judgment? Accused. Where is the conviction part in the
Yes, ma'am.
judgment?
Page 40.
Page,
Lordship taking item number 8, my lord. See,
whatever, judgment is everywhere. Judgment. Paragraph,
Page 54, my lord.
paragraph 54,
54, my lord.
namely Alauddin, Yu Chuchiang Khasia,
And Vijay.
Bijoy
Amse.
Amse. They are the convicted person.
They are the convicted person.
Alauddin, Bijoy Amse, Yu Chuchiang. Okay. 302,
302, my lord.
149.
149. And Arms Act is also.
Why 149? There were no 5.
There were 5, my lord. Between
There were 5.
Yes, my lord. 2 groups.
Few died or what?
Was the other side, my lord, who's.
Now, why it has come?
My lord, paper book has been prepared in this matter.
Shall take steps, service of notice, respondent number 2. Okay.
Service is complete.
Respondent number 2 means informant.
Informant, my lord.
Service report has been received from the officer of CGM Karimganj. The same is tagged at SR in supplementary files. What does it? Also. Service to complete supplementary file. What does it? Supplementary file. Same is tagged as at SR in supplementary file. Who is the informant? Abdul Majid.
Abdul Majid, my lord.
Huh?
Abdul Majid.
Abdul Majid.
Abdul Matlib, my lord.
Huh?
Abdul Matlib, son of late.
Abdul Motlib.
Motlib.
Yes, yes. Abdul Motlib. তিনি নকল নোটিশ সমঝিয়া নিয়েছেন। সমঝিয়া নিয়েছেন।
Yes,
Accepted.
accepted.
Okay. Heard Mr. M.A. Choudhury, learned counsel for the appellants in 7 and 8. And Mr. L.R. Mojumdar, learned counsel for the appellant in 9. Also heard M.S. A. Begum, learned counsel for the respondent number 1, state of Assam. Post up. As per office note dated 5/8/2024, in criminal appeal number 374/2023, a report as regards service has been received as regards service upon the respondent number 2, comma, Abdul Motlib has been received from the officer in charge from the office of the Chief Judicial Magistrate, comma, Karimganj. Full stop. ये बाकी तो था appeal के था. Respondent number 2. As the respondent number 2, comma, Abdul Motlib, as I said, respondent number 2, Abdul Motlib, in criminal appeal number 374/2023, is also the respondent number 2 in the other 2 criminal appeals, comma, criminal appeal number 355/2023 and criminal appeal number 368/2023, comma. The service of notice upon respondent number 2, Abdul Motlib, is treated to be complete as all the criminal appeals are tagged together for hearing together. Full stop. As the paper is ready, no?
Ready, my lord.
Huh?
Paper book ready.
As the paper book is ready, release the 3 appeals for hearing in the
No.
Item number 10.
In this case, my lord, mostly they filed objection yesterday, my lord. It has not come under the record.
Okay. Next week,
Here we have received.
Mr. P. Kotoki, learned counsel for the applicant appellant, and MS A. Begum, learned additional public prosecutor for the opposite party number 1, comma, state of Assam. Heard, huh? MS Begum has submitted that an objection from the side of the state has been filed yesterday by serving copy to the learned counsel for the applicant appellant. Full stop. As the said objection, comma, stated to have been filed by the state, comma, is not tagged with the case record, list the case in the next week.
Next week.
With the said objection on record.
The number
Dated 7.
Service,
Offenses 302 and 201.
Mr. heard Mr. J.P. Das,
Jay Dasan.
J. Das,
Jay.
J. Das, learned legal aid counsel for the appellant, and MS A. Begum, learned additional public prosecutor for the respondent number 1, state of Assam. Full stop. Service report, as per office note. Alright. Service report. A report as regards service of notice upon the respondent number 2 has been received from the office of the Chief Judicial Magistrate, comma, Siran, within bracket BTAD, comma, Kajalgaon, stating that service note of service has been duly affected upon the respond number 2. Full stop. A copy. Alright. In view of such report, the service of notice upon the respond number 2 is treated to be complete, as the case records from the trial court have been received. Ready to take steps for preparation of the paper book.
Yes, sir.
Is after 4 weeks.
High level.
Item number 13,
Is prepared, seeking condonation of delay of 69 days.
66 days.
69 corrected here.
Oh, corrected.
69 days. Stated to have occurred in filing the accompanying criminal appeal under section 374 2, Code of Criminal Procedure 1973. Read it or what?
No, Lordship. Only single section.
It should be read it. No, NDPS account. Read it. Section 36B of the Narcotic Drugs and Psychotropic Substances NDPS Act 1985. Full stop. The accompanying criminal appeal is preferred against a judgment in order dated 2/2/2024. Passed by the Court of Law and Special Judge Bongaigaon Special Court for Salt. Judgment ordered 2/2/24 disposition in special within bracket NAR case number 05 within bracket BGN of 2023. By the judgment and order dated 2/2/2024, the appellant has been convicted for the offense under section 22 within bracket small c of the NDPS Act 1985, and he has been sentenced to undergo rigorous imprisonment for 12 years and to pay a fine of rupees 1 lakh, in default of payment of fine, to undergo simple imprisonment for another 6 months. Full stop. The applicant has explained the reasons for the delay of 69 days in preferring the accompanying appeal in paragraph 4 of the application. Full stop. We have gone through the statement and averments made in this application, more particularly, in paragraph 4 thereto. Full stop. Para. 4 and 5. Hmm? MS Begum, learned additional public prosecutor appearing for the state, has submitted that as on that, no instruction has been received to oppose the instant application, which is preferred for condonation of delay. Full stop. Para. The appellant has been sentenced after being found guilty of the offense under section 22C of the NDPS Act, has been sentenced to undergo rigorous imprisonment of 12 years and to pay a fine of rupees 1 lakh with default stipulation. Full stop. We have considered the reasons shown for the delay, and having gone through the same, we find that the applicant has been able to has been able to explain the period of delay showing sufficient cause. Full stop. In any view of the matter, we find that ends of justice will be better subserved if the accompanying appeal is hard on merits. Full stop. Accordingly, the instant application is allowed, condoning the period of 69 days. Of delay beyond the period of limitation. Full stop. The register the accompanying appeal and to list the same thereafter, admission. For
Okay.
Item number 15.
Mr.
K Thakur, Lordship.
K. Thakur, applicant appellant. Applicant 168 days. A. Begum for the opposite party number 1, state of Assam. 168 days. Accompanying appeal. Accompanying appeal is preferred against a judgment and order.
412.
Judgment and order dated 4/11/2023, passed by the Court of Learned Additional Session Judge Special Judge, POCSO, Kamrup, Metro, Guwahati, within bracket.
So basically, also hitting part was by the back of the handle of the Cipran, not with exactly the Cipran. I have not seen the incident. Since I haven't seen the incident, so I cannot say.
Cipran is not otherwise very sharp
But
object.
not very sharp, not very sharp. It is
It
used
is basically blunt.
blunt.
One part is even that the sharp part is also bit blunt.
Very thick. It's thick because
Not
it's
Pointed,
yeah,
not a
correct.
pointed one,
Not a
but
pointed
heavy one.
Heavy. It used for the digging of the article. Since I have not seen the incident, so I cannot say how he died. He may be died due to falling on hard substance after intoxication, or may be died due to assault by heavy object. The above statement I have deposed today, I deposed only for the first time. I do not know in what paper police put my thumb impression. Then Lordship PWT 3 at page 16, his name is Thuma Urang. I know accused Jugen Munda. I also know this is Chanika Munda, who the father of accused. The incident took place about 2 years ago. I have heard that accused killed his father. Police seized one Siprang through exhibit 1. Exhibit 1 is my signature. I was present at the time of conducting inquest upon the dead body by the IO. Exhibit 2 is the inquest report and exhibit 2.1 is my signature. I know that disease used to consume liquor heavily, and after consuming liquor, he fell hither and thither. Since I have not seen the incident, so I cannot say how he died. He maybe died due to falling on hurt substance after intoxication, or maybe died due to assault by a heavy object. I do not know why police obtained my signature, as police asked me to put signature. Only because of that, I have put my signature. I haven't seen any Siprang before this court. Then Lordship PW4 Abdul Hasim at page 18. I know accused Jugen Munda, who is absent today. The incident took place about within last 2-3 years. At about 5:10, 5:20 p.m., I went to my parental house. I have one tractor. In the said tractor, one Kalyan is doing as a helper. On the way to my parental house, I met said Kalyan, asked him to come back. During that time, accused Jogen Munda assaulted Sanika Munda by a Siprang with a bamboo handle. I myself seen accused in assaulting Sanika. Sanika is the father of accused Jogen. Accused Jogen dragged Sanika to his home. I came to know in the next morning that said Sanika was died. When the local people dig a trance for cremation of the dead body, I asked them to inform the matter to the police as the case was a murder. Then I lodged the Azahar. Exhibit 3 is the Azahar. Exhibit 3.1 is my signature. After lodging the Azahar, police visited the place of occurrence and interrogated us, conducted inquest upon the dead body, and thereafter the dead body was taken for post-mortem examination. Exhibit 2 is the inquest report, and Exhibit 2.2 is my signature as a witness. My wife has filed a criminal case against me, which was compromised. There is also a civil case pending against me. The accused house is at a distance of 500 meters from my house. Police recorded my statement. It is not a fact that I have not stated to the police that at about 5:10, 5:20 p.m., I went to my parental house. I have one tractor. In the said tractor, one Kalyan is doing as a helper. On the way to my parental house, I met said Kalyan, asked him to come back. During that time, accused Jogen Munda assaulted Sanika Munda by a Siprang with a bamboo handle. I myself seen accused assaulting Sanika. Sanika, the father of accused Jogen, dragged Sanika to his home. I came to know in the next morning that said Sanika was died. When the local police public dig a trance for cremation of the dead body, I asked him to inform the matter to police as the case was a murder. Exhibit 3 was written by one scribe named Mutaleb. The scribe has read over the contents of Azahar, and on my acceptance, I put my signature thereon. It is not a fact that in the Azahar, I have not stated what I have deposed today in my examination in chief. I know that deceased and accused both were consumed liquor. It is not a fact that the deceased died after falling due to consuming excessive liquor. Jogen Munda has wife and children. He has also one brother and one younger brother. Charan Maji is the adjacent neighbor of Jogen Munda. It is not a fact that due to enmity with the accused, I have filed this case against him falsely. Lordship PW5 at page 20, Fazar Ali Ahmed. I know accused Jogen Munda, who is absent today. Incident took place in the year 2016. I am Sarkari Gaonbura of Polasbosti Pothar. I know the deceased Sanika Munda. Sanika is the father of accused Jogen. The incident took place at about 5-6 p.m. Somebody of our village informed me that Sanika was murdered by his son Jogen Munda. Accordingly, I rushed to the place of occurrence, and there I saw a gathering of people there. I asked one Devon about the incident, and said Devon told me that deceased used to consume liquor in every day, and on that very day he was murdered. Then I asked the wife of the accused, and she reported me that after consuming liquor, he killed his father. During investigation, police has seized one bamboo-handled Cipra. Exhibit 1-3 is my signature on Exhibit 1 seizure list. This examination part, police recorded my statement. It is not a fact that I have not stated to police that the incident took place at about 5-6 p.m. Somebody of our village informed me that Sanika was murdered by his son Jogen Munda. Accordingly, I rushed to the place of occurrence, and there I saw a gathering of people there. I asked one Devon about the incident, and said Devon told me that that deceased used to consume liquor in every day, and on that very day he was murdered. Then I asked the wife of the accused. She reported me that after consuming liquor, he killed his father. I have put my signature on Exhibit 1, seizure list as per instruction of OC Tekiajuli. I have not seen the said bamboo-handled Ciprang today in the court. I do not know how Sanika Munda died, as I have not seen the incident personally. It is not a fact that today I have deposed falsely. Then Lordship, page 22, PW6, this is Biren Munda. I know accused person Jogen Munda. The incident took place about 2 years ago in the evening at about 3-4 p.m. I met the Sanika Munda, who is my uncle Bodota, lying on the road, and taken him to our house. Thereafter, I also took him to their house. Accused Jogen Munda is the son of Sanika Munda. In the evening time, Sanika Munda died in the house of Jogen Munda. I came to know that a quarrel took place in between accused Jogen Munda and his father Sanika Munda. At this stage, the witness is declared hostile by the prosecution, Lordship. Cross-examination by prosecution, it is not a fact that I have stated to the police that due to assault of Jogen Munda, his father Sanika Munda died. In the cross-examination part, my defense, the Sanika Munda, who was aged 85 years old, used to consume excessive liquor. I cannot say whether Sanika Munda died by falling on the ground or due to fight. I have not made statement before the IO that Jogen Munda assaulted Sanika Munda. He has been declared hostile. Now, Lordship, page 24, deposition of QW.
Star witness.
Yes, Lordship, yes. She is victim of assault, Lordship. My name is Srimati Parvati Munda. Accused Jogen Munda is my husband. The incident took place more than 1 year in the evening at about 3:40 p.m. At that relevant time, I was in my house. At the relevant time, while I was sleeping, my husband, my father-in-law, this is Sanika Munda, draws my clothes. In the meantime, my husband Jogen Munda saw the incident and then assaulted my father-in-law by means of a Ciprang. As a result of injury, my father-in-law was died. Then I went to my parents' house. After returning from my parents' house, I saw the dead body of my father-in-law. During investigation, police seized the said Ciprang by which the accused assaulted the deceased. The said Ciprang was produced by me. Thereafter, Muhammad Abdul Hasim filed a case before the police station. Police took the dead body for post-mortem examination. Cross-examination by defense. On relevant time of the incident, my husband and my father-in-law were in our house. When my father-in-law only draws the clothes out of fear, I fled away to the neighbor's house. Thereafter, I do not know what happened in between my husband and my father-in-law. On that day, my father-in-law consumed excessive liquor. I cannot say if my father-in-law sustained injury on falling due to intoxication On being asked by police, I handed over the Siprang to police. By that, Siprang did not assault my father-in-law. So there was little bit of, difference in. But as far as the assault is concerned, that is there, he specifically stated. Now, PW 8 Lordship, page 26, Ranjan Kumar Mohanta. He is a medical officer. On 12/4/2016, I was working as a medical officer 1 at Kanaklata Civil Hospital, Tezpur, and on that day I performed post-mortem examination at about 3 p.m. on the dead body of Sanika Munda, male 62 years, Hindu, son of late Mikhail Munda of village Palas Bosti, PS Dhikiazili, in reference to Dhikiazili police case number so and so under IPC. On being escorted and identified by UBC Tutu Khan and Tuna Urang. On examination, I found the following. External appearance. A male dead body of Sanka Munda, rigor mortis present, abrasion over right side of the chest and right leg. Fracture of right clavicle and fracture of ribs 8th and 10th right side of the chest. So injury is basically on the right side of the chest in the ribs. Hematoma seen both lungs, abrasion on the right chest wall, both larynx and trachea are congested. All other organs are healthy, abdomen wall healthy. The injuries are antemortem in nature. Opinion. In my opinion, the cause of death was due to shock and blunt chest injury sustained by the deceased. The injury described in my report is sufficient to cause the death of a person. Exhibit 4 is a postmortem report, and Exhibit 4.1 is my signature, and Exhibit 4.2 is the signature of Joint Director of Health Services, Sonitpur, Tezpur, which is known to me. Cross-examination part, the such type of injury may be occurred if the patient falls in blunt surface. PW 9 Lordship, page 28. SI Chandrakanta Bhuya. On 12/4/2016, I was posted as attached officer at Dhikiazili police station. On that day, on receipt of an FIR from Abdul Hasim, officer in charge Dharmakanta Bora, registered Dhikiazili police case number 206/16 under section 302 of the IPC and endorsed me to investigate the case. Accordingly, I visited the place of occurrence, that is the village Palas Basti, and found the dead body of Chanika Munda on being identified by one Gulatati. I seized one Siprang from the place of occurrence in presence of witnesses. Exhibit 1 is the seizure list and Exhibit 1.4 is my signature. Circle Officer Joyanta Sarkar conducted inquest on the dead body. Exhibit 2 is the inquest report, wherein Exhibit 2.3 is my signature. I noticed injury mark upon the chest and back of the deceased. I recorded the statement of the witnesses at the place of occurrence and prepared the sketch map of the place of occurrence. Exhibit 5 is the sketch map and Exhibit 5.1 is my signature. I also sent the dead body for postmortem examination to ACH Tezpur. When I went to the place of occurrence, I did not find the accused there. And in the evening, knowing that the accused Jogen Munda was hiding in the house of one Thuma Urang, I went there and arrested the accused therefore. On conclusion of investigation, I submitted charge sheet against the accused Jogen Munda under section 302 of IPC. Exhibit 6 is the charge sheet and Exhibit 6.1 is my signature. Witness Biren Munda stated before me that due to assault of Jogen Munda, his father Sanika Munda died. Cross-examination part, Your Lordship. On 12/4/2016, the case was registered at 8:30 a.m. and I proceeded to the place of occurrence at 8:40 a.m.
Yes.
The house of Bhola Tati is situated near the house.
What are the calculation?
Yes.
The house of Bhola Tati is situated near the house of the accused. In the sketch map, the house of Bhola Tati was not mentioned, but the name of Bhula Munda was mentioned. The walking distance between the place of occurrence and the house of Bhula Munda is about 5 minutes. The inquest was conducted at the place of occurrence. Today, I have not seen the seized Siprang. It is not a fact that I seized no article. I did not notice blood stain on the dead body. Witness Abdul Hasim did not state before me that at about 5:10:20 p.m. I went to my parental house. I have one tractor. In the said tractor, one Kalyan worked as a helper. On the way to my parental house, I met Said Kalyan and asked him to come back. I myself had seen I came to know in the next morning that Said Sanika was died. When the local public did get trends for cremation of the dead body, I asked them to inform the matter to police as the case was a murder. He stated before me that accused Jogen Munda assaulted Sanika Munda by a Siprang. Witness Muhammad Fazar Ali Ahmed did not state before me that the incident took place at about 5-6 p.m. Somebody of our village informed me that Sanika was murdered by his son Jogen Munda. Accordingly, I rushed to the place of occurrence and there I saw a gathering of people. I asked one Deben about the incident and said Deben told me that the deceased used to consume liquor in every day and on that very day he was murdered. Then I asked the wife of the accused and she reported me that after consuming liquor he killed his father. It is not a fact that witness Biren Munda did not state before me that due to assault of Jogen Munda, his father Sanika Munda died. It is not a fact that without finding any sufficient materials against the accused Jogen Munda, I submitted the charge sheet against him under section 302 of the IPC. Now, page 31, Lordship, Jayanta Sarkar. He is a circle officer who conducted the inquest. On 12/4/2016, I was serving as circle officer in Dhekazili Circle. On that day, at around 9:45 a.m., the officer in charge Dhekazili Police Station informed me that an inquest is required to be carried out in connection with Dhekazili Police Station case number 206/2016 under section 302 IPC. Accordingly, I visited the house of Golatati of Palasbosti village under Dhekazili Police Station and did inquest on the dead body of Sanika Munda, 62 years, son of late Mikhail Munda. I have seen injury mark on the backside of the deceased. I have heard from the witness that deceased was murdered by attacking with a jumper, an iron instrument. Exhibit 2 is the inquest report and Exhibit 2-4 is my signature. No cross-examination.
So it appears section 300, thirdly or fourthly, the man was of 85 or 62, whatever, in between 60 plus, in between 60 to 85.
As per the postmortem report, 62 and like other witnesses. 62.
And somebody said his
85
his who was the disease was his body, he said
yes,
85.
85.
So he is a elderly man,
60 plus.
elderly man,
60 plus. Yes.
and too habituated with alcohol.
Yes. Yes.
Siprang is not a lightweight thing.
Yes.
His ribs were fractured as a result of the blow.
Yes.
So it comes under either thirdly or fourthly of section 300. Then if we travel further, whether under which exception it could come.
Yes. So in my humble submission,
There is a cause for the accused to react as evident from the star witness,
yes, Lord.
who was incidentally his own wife.
Yes, Lord.
And so there is nothing to disbelieve her testimony.
Yes, Lord.
And she was a natural witness inside the house.
Yes, Lord.
And it appears from that body of who said that
Mm.
he found the disease in an intoxicated condition and was on the road while he was sleeping or something, was on the road. He took him to the house of the accused, lived there. And thereafter, the incident happened.
That is his version, Lord. That is his version
No,
and
that
he
is
has,
not discredited, not his version. Now it has become evidence.
he has been declared
That
hostile
has
also,
become
sir.
who? To that part.
Yes, yes.
The entire evidence, yes,
Yes.
we have found that in the trial,
Yes,
the
Lord.
defense counsel has rightly brought the contradiction in case of the informant and the next witness,
Yes,
right?
yes, Lord, sir.
But so far, this witness is that witness is concerned, he brought only one part.
Mhm.
That part is to be discarded, but the entire evidence is not to be discarded. That is not the law. The part which is in support of the prosecution can be accepted. That is the law. So
Correct,
that
correct. I
part,
do not disagree with
leaving
that.
the deceased after finding him on the road in an intoxicated condition in the house of the accused,
Mhm.
that part is not.
I agree, Lord, sir.
Wiped
I
out.
agree. I do not disagree.
So now we proceed further
Correct,
from 300 to the exceptions,
correct.
whether any of the exceptions could come or not, and what are the ingredients to bring in the exception,
Correct,
and which of the exception.
correct. Correct, Lord. sir.
Let us
Let us
get
examine.
limited to the point.
Yes, let us examine it. Lordship, first of all, Lordship, let me point out a couple of things. First of all, there is an eyewitness, Abdul Hasim, who is PW4.
I have
He-
already said.
He has specifically stated that there was a quarrel and he has assaulted him. That is there.
No, that
Page 18, Your Lordship.
has been contradicted.
No, no,
Contradiction has been brought out.
that has not been contradicted, Lordship.
No, I have seen it.
Page, Lordship.
Come to page
Page 18, Lordship.
18.
Yes, yes.
Now from the second line,
Yes, Lordship.
right? Abdul Hasim.
Yes.
Second line at about 5:10
5:10,
5:20
5:20 p.m.
and up to
Yes,
as the case was a murder, right?
yes,
That part come to his cross-examination. That part was marked and was asked to him.
that was marks to him.
Marked
Yes.
and asked to him,
Yes,
right?
yes,
Then come to page 29. IO was confronted with that marked part of the testimony of PW 5:4. And IO said that this witness did not say like this before me
correct.
in his 161.
161.
So this goes.
So-
This goes.
161 he hasn't said, but in examination, the chief, he has specifically said so.
No, mister.
How it will go, Lordship?
This is a contradiction on material particulars.
Material particular, I mean, 161, it says that he hasn't stated anything like this. Once police said that under 161, he hasn't stated like this. If the para has been quoted, his statement has been quoted, but his statement is there in the examination in chief. And in the cross-examination part, he said that it is not a fact that I have not stated to the police. I have not stated to the police. So he hasn't stated to the police, but he has stated he is deposed before the when the trial was on, he was deposed before the trial court. He stated that he hasn't stated this statement before the police. And
So, what is the way
Yes,
a contradiction can be brought on record. CRPC.
yes, Lordship. So there is nothing, there is no contradiction in his statement as far as like this statement is concerned, because he stated that I have not stated before the police about this. I have deposed before the, I have deposed before the trial court. So,
Read VK Mishra.
yes.
Read VK Mishra. Come back at 2
Okay.
and many others.
I have gone through this, Lord. This proposition is, Lordship, like, I'm aware of.
Contradiction has been the learned defense counsel.
Yes,
He had rightly brought out the contradiction. So, except their testimony as regards witness to the inquest proceeding, the other part of the evidence has no value, is not adding anything to the prosecution case.
yes,
So far as the PW4 and PW5 are concerned, major part of their testimonies are proved as contradiction.
contradictions. Correct.
So that is what it is in your
Right.
favor.
In my favor only, that's what, Lordship.
So that is the way the learned defense counsel is well acquainted with the procedure. In very few cases, we find this kind of cross-examination.
Correct, Lordship, correct.
So the line you were arguing,
That may not be helpful to, correct, Lordship. I'm obliged to your Lordship.
Lordship, probably it would come under exception 1. When culpable homicide is not murder, culpable homicide is
it
not.
is better than Nanavati.
Yes, my lord. Lordship. So, Lordship, I leave it to your Lordship whether it would come up on a 304 part 2 or part 1.
Yes, it
Because
appears.
weapon of assault, although it is not discernible from the evidence that he was equipped, he was not equipped, it was under grave and sudden provocation, my lord. But
Because PW7 perhaps.
7 is the why.
why?
Her testimony was not second,
My lord.
right? Though the defense counsel was successful to discredit PW4 and PW5,
My lord.
but he was not successful enough to discredit. And testifying against the act of the husband, she appears to be a reliable one.
Reliable. But
And
you know,
the story
my lord.
she projected appears to be one which has resulted into grave and sudden provocation,
And Lordship.
loss of said control.
Yes, Lordship. One more thing is that like as far as the prosecution story and like charge sheet they have filed, they have stated that like this is the story. I mean, charge sheet, Lordship, will find is at page 67, but like relevant portion, Lordship, page 71, Lordship, will find page 71. So here, second paragraph, your Lordship, page 71. I'll just read out. In the course of investigation, the statements of the witnesses revealed that around 5:30 p.m. on 11/4/2016, when the accused Sri Jogen Munda saw his father Chanika Munda touching private parts of his own daughter-in-law, the accused assaulted the.
It cannot be finished today.
Lordship,
Roll over
304 part 1 or part 1?
part one.
Part 1.
Because if we travel by Raya, that Visasi
My lord, yes, sir.
and Punayappa, then we have to travel by 299, 300, then to exception.
Right.
If we travel by exception, then it will be part 1.
Right.
Because it comes under either thirdly or fourthly. The man was a more than 60 years of age with a Siprang which is not that lightweight. If somebody with force hits the chest of such a person who is already intoxicated, it is
Result.
likely to, and PM is clear.
I know.
PM is clear.
No, but Lordship, this, the evidence is that the handle has been used and like it was not multiple injuries, that intention was there.
Yes, there are
It was only one stroke, maybe
One
one
stroke,
stroke in
but
sudden
if it is,
provocation.
see the testimony of the doctor.
Yes, Lordship. It
See
is
the
at page,
testimony of the doctor.
Page is at postmortem report or testimony?
See the testimony of the doctor.
DW8.
Yes.
Injury described in the report is sufficient to cause the death of a person.
Yes.
Now see thirdly. Thirdly,
If it is done with the intention of causing bodily injury to any person and a bodily injury intended to be inflicted
then
is sufficient.
discussing and exception, illustration C,
Illustration C.
section 300.
My lord. A intentionally give jet. A sword cut or club wound sufficient to cause the death of a man.
Birsa Buddhi. Buddhi.
Lordship is
We can-
referring to
Illustration C of section 300.
We can straightaway say from Birsa Singh, which is still relevant,
My lord.
though it was up to 1956 or something. Buddhi. Buddhi. Punayapa to Kutkun. Punayapa. Punayapa. Birsa Singh was explained in Punayapa. Thus, according to the rule laid down in Birsa Singh case, even if the intention of the accused was limited to the infliction of a bodily injury sufficient to cause death in the ordinary course of nature and did not extend to the intention of causing death, the offense would be murder. Illustration C appended to section 300 clearly brings this point. And single injury or double injury, it is not material sometimes.
but like, he didn't use this that sharp portion.
Even Lathi murder. But the defense did not bring anything on record to bring in the exception.
They didn't bring it. That is correct, but at this stage also, Lordship, I mean, Lordship can really appreciate the whole thing.
We'll do that.
Yes, Lordship. Then Lordship,
This criminal appeal under section from jail under section
Lordship,
383.
Lordship, I have one request, Lordship. I have a fixed matter at court number 17. Lordship, may kindly excuse me, Lordship.
Code of
My
Criminal.
junior will be here, Lordship.
Procedure 1973, the CRPC order code is directed against a judgment and order dated 23/02/2022. We have started on the premise that if it is not complete, we will roll it over to Monday or
Next week.
Tuesday. because we both have single
Single
benches.
benches.
23/2/2022 passed by the Court of Learned Session Judge Sunitpur at Tezpur. In Sessions case number 23 of 2018. Full stop. In the trial of Sessions case number 23 of 2018, the accused appellant faced a charge of patricide, and after conclusion of the trial, the Court of Learned Session Judge so and so, within bracket, the trial court, finding him guilty for the offense of murder under Section 300, Indian Penal Code, has sentenced him under Section 302, IPC to undergo rigorous imprisonment for life and to pay a fine of rupees 1,000, in default of payment of fine, to undergo simple imprisonment for another 3 months. Full stop. The Learned Trial Court has observed that the period of detention, if any, already undergone by the accused during the course of investigation, trial, inquiry or trial shall be set off against the term of imprisonment in terms of Section 428, CRPC. Full stop. The investigation was set into motion on institution of a first information report by one Abdul Hasim, PW4 as the informant, before the officer in charge, Thekiajuli Police Station, on 12/4/2016. Full stop. In the FIR, the informant stated that at around 6:30 p.m. on 11/4/2016, the his fellow villager, Soinaka Munda, is the deceased, was assaulted to death by his own son, Zugen Munda, that is the accused. Full stop. Are man? On receipt of the FIR, EXT 3, The officer in charge, Thekiajuli Police Station, registered the FIR as Thekiajuli Police Station, case number 206/2016 for the offense under section 302, IPC. After registration of the case, the investigation was entrusted to one Chandrakanta Bhuya, a sub-inspector of police attached to Thekiajuli Police Station. Chandrakanta Bhuya is PW9. On being so entrusted, the IO PW9 visited the place of occurrence, that is, the house of the deceased and the accused, situate at village Polah Bosti. Going there, the IO found the dead body of Chainaka Munda lying there, and the dead body was identified by one Vola Tati. At the place of occurrence, the IO found one Siprang, SIPRANG, and the said Siprang was seized by a seizure list, EXT1. In presence of witnesses, including Kuma Urang, PW3, and Fajr Ali Ahmed, PW5. The IO also held the inquest proceeding on the dead body of the deceased at the PO inquest report.
Page 80, 55.
55. True. The circle officer, through Jayanta Sarkar, the circle officer, Thekiajuli Circle, Jayanta Sarkar, PW10. Jayanta Sarkar, PW10, circle officer, Thekiajuli Circle, after completing the inquest, recorded his findings in an inquest report, EXT2. After completion of the inquest proceeding, the dead body was forwarded to the Konaklata Civil Hospital, Tezpur, for post-mortem examination. On 12/4/2016 itself. Full stop. The postmortem examination on the dead body of the deceased was performed at Kanaklata Civil Hospital, Tezpur, at around 3 p.m. on 12/4/2016 by Dr. Ranjan Kumar Mohanto, PW 8, who was serving as the medical and health officer -1 therein on 12/4/2006. Post of the autopsy, Dr. PW 8 had thereafter submitted a postmortem examination report EXT 4 recording his findings therein. Post of the IO PW 10 had, in the meantime, prepared a sketch map of the PO EXT 5 and recorded statements of the witnesses available at the PO. Full stop. As the IO PW 10 did not find the accused at his house, he made a search for him. Full stop. On receiving a news that the accused was hiding himself in the house of Thuma Orang PW 3. The IO PW 9 went there, had arrested the accused from the house of Thuma Orang PW 3 and forwarded the accused before the jurisdictional magistrate. After collecting the post-PME report and completing the remaining part of the investigation, PME report means EXT 4. After completing the remaining part of the investigation of the case, Rekiazuli Police Station case number 206/2016, within bracket corresponding ZR case number 1068/2016. The IO PW 9 submitted a charge sheet under section 173 to CRPC. Provide charge sheet number 124/2016 on 26/4/2016, finding a prima facie case well established for the offense under section 302 IPC against the accused. Poster. In the charge sheet, EXT 6, the IO observed that it was revealed from the statements of the witnesses that at around 5:30 p.m. on 11/4/2016, When the accused saw his father touching the private parts of his pusto, pera. After submission of the charge sheet, the court of learned Judicial Magistrate First Class Tejpur issued summons to the accused for his appearance as the accused was, in the meantime, allowed to go on bail. Full stop. On receipt of the summons, the accused appeared before the court of learned Judicial Magistrate First Class Tejpur on 1/12/2018. Full stop. On his such appearance, the accused was furnished with the copies of the case in compliance of the procedure laid down in section 207 IPC. Full stop. Also ARPC. As the offense under section 302 IPC is exclusively triable by the Court of Sessions, the learned Judicial Magistrate First Class Sonitpur or Tejpur committed the case records of GR case number 1068/2016 to the Court of Sessions Tejpur Sonitpur Trial Court for trial. Full stop. The learned additional public prosecutor was accordingly notified. Full stop. The accused was directed to appear before the learned Court of Sessions or before the trial court, learned trial court on 19/2/2018. Full stop. Para. On by an order of commitment dated 1/12/2018. On receipt of the case records of GR case number 1068/2016 pursuant to the order of commitment dated 1/2/2018, the learned trial court registered the case as Sessions case number 23/2018. Full stop. After appearance of the accused, the case was opened by the learned public prosecutor before the trial court. Full stop. After hearing the learned public prosecutor and learned defense counsel, and upon perusal of the materials on record, the learned trial court framed the following charge on okay. 3/4/2018, against the accused person, page 10. When the charge was read over, interpreted, and explained to the accused, he pleaded not guilty and claimed to be tried. Full stop. During the course of the trial, the prosecution side examined 10 number of witnesses, and they were page index and they were page index. Post The prosecution side also exhibited the following 6 number of documentary evidence: 1, 2, 3, 4, 5, 6. Full stop. After closure of evidence from the prosecution side, comma, the accused was examined under section 313, comma, thereby, comma, providing an opportunity to him to explain the circumstances which had appeared from the prosecution, which had appeared against him from the prosecution evidence. Full stop. The plea of the accused was denial. Full stop. When the accused was asked as to whether he would adduce any evidence in his defense, comma, he declined to adduce any evidence. Full stop. After hearing the learned arguments of the learned counsel for the parties, and after evaluation of the evidence stock materials on record, comma, the learned trial court delivered the judgment on 23/2/2022, recording the finding of guilt against the accused for committing the offense of murder. Of his father. Full stop. The accused was heard on the point of sentence under section 235 within bracket 2, comma, CIPC, and thereafter, comma, he has been sentenced in the manner, comma, indicated above. Full stop. Para, we have heard Mr. A. Kolita, learned counsel, learned amicus curiae for the accused appellant, and MS B. Bhuiyan, learned senior counsel and additional public prosecutor assisted by MS M. Chakraborty, learned counsel for the respondent state. Full stop. Mr. Kolita, learned amicus curiae appearing for the accused appellant, has submitted that leaving aside other than the wife, daughter-in-law of the deceased and the wife of the accused, comma, PW7, the other witnesses, the testimonies of the other witnesses are not to be accepted on the point of, as regards the alleged incident of assault. Full stop. He has contended that the prosecution witnesses, comma, PW1, PW2, PW3 were, and PW3 were only witnesses to the seizure list, and to the seizure and to the NPS proceeding. Full stop. The other part of the testimonies of these witnesses cannot be accepted as they did not see the incident. Full stop. Insofar as the prosecution witnesses PW5 and PW4 and PW5 are concerned, he has submitted that the defense was successful to establish that their testimonies are not trustworthy. Full stop. It is his further contention that even if the prosecution, it is further condition that the prosecution case is solely based on the testimony of PW7, that is, the daughter-in-law of the deceased and the wife of the accused. And such testimony is to be is not to be accepted due to lack of corroboration from the other evidence. Full stop. He has, Mr. Kolita, learned amicus curiae has alternately submitted that even if the case is found to be one of murder under section 300 IPC, the materials emerging from the case record have clearly pointed towards an act towards an act on the part of the deceased towards his daughter-in-law, which was unbecoming on the part of an elderly person like him. Full stop. Which such submission, the amicus curiae has submitted that in such case, in such situation, the case would definitely come within the exception 1 of section 300 IPC. Full stop. Para. MS Fuel and senior counsel and additional public prosecutor appearing for the state. has supported the judgment and order of conviction and sentence of the learned trial court. Post of MS Bhuiyan has submitted that the prosecution has been able to prove the case beyond reasonable doubts. Full stop. MS Bhuiyan has further contended that the testimony of the prosecution witness, PW7 could not be shaken and discredited by the defense, and as such, and full stop. Since the testimony of PW7 is found reliable and credible as regards the incident of assault, the conviction based on the testimony of the said witness is clearly permissible under the law. Full stop. It has been fairly submitted that even if the case is found to be full stop, even if the submission of the learned amicus curiae is accepted, the case would at best be under part 1 of section 304 IPC. First stop, para. We have given due consideration to the submissions of the learned counsel for the parties, and have also gone through the evidence stroke materials on record, including the testimonies of the prosecution witnesses and the documentary evidence, available in the case records of sessions, case number so and so in original. Full stop. Para. Before any discussion on the ocular testimony of the witnesses, it appears apt to refer to the medical evidence which are in the forms of the testimony of the autopsy doctor, PW 5 or 8, PW 8, and the post PMA report EXT4, coupled with along with the inquest report EXT2. Full stop. Subhead. The inquest proceeding was conducted by Soyendra Sarkar, PW 10, Circle Officer, Tekio Judicial Circle, at the place of occurrence on 12/4/2016. Full stop. In his testimony, Peter Lutin deposed that when he conducted the inquest proceeding, he noticed injury marks on the backside of the deceased. Full stop. He exhibited the inquest report as EXT2 with his signature therein as EXT24. Full stop. In the inquest report EXT2, it was reported that the approximate age of the deceased was 62 years and there was injury mark on the backside of his person. Full stop. The inquest report was like Doctor Ranjan Kumar Mohanto. PW 8 was on 12/4/2016, was serving as the medical and health officer 1 at Konaklata Civil Hospital, Tejpur. Full stop. In his testimony, PW 8 deposed that he performed postmortem examination of the dead body of the deceased. Sanda, what he is mentioning? Sanda, Sanka Munda. What is the name of the deceased?
Page 59.
Huh? What is the name of the deceased?
Sanka Munda.
Huh?
Let me see the FIR, madam.
Let us see the
Sanika
FIR.
something.
Soinaka Munda. Anyway, on the dead body of the deceased.
Child.
Manasi page 2. Yeah. At about 3 p.m. on 12/4/2016, in reference to the Kiazuri police station, case number 206/2016, after the dead body was identified by EBC, Tutu Khan and Thuma Orang, PW 3. In his testimony, PW 8 mentioned about the injuries found on the person of the deceased. Full stop. He stated that there was abrasion over the right side of the chest and right leg. Full stop. There were also fracture of the right clavicle and fracture of ribs 8 and 10th on the right side of the chest. Hematoma was seen in both lungs. Full stop. There was abrasion on the right chest wall and both larynx and trachea were found congested. Full stop. PW8 further stated that the injuries were were found to be antemortem in nature. Full stop. On the basis of such findings, he opined that the cause of death was due to shock and blunt chest injury sustained by the deceased. Full stop. PW8 further testified that the injury described in the PMA report was sufficient to cause death of a person. Full stop. PW8 exhibited the PMA report as EXT4 and the signature and his signature and the signature of the Joint Director of Health Services, Sunitpur Tezpur, therein as EXT41 and EXT42 respectively. Full stop. When cross-examined, PW8 mentioned that the injury of the type sustained by the disease could occur if a person falls on a blunt surface. Full stop. Subpara. In the PME report, EXT4 following findings were recorded. Page 60 for us. Mark it for us. Where? Where? PW1 Deven Kormakar is a co-villager. Is an inhabitant of village Polak Bosti. Full stop. He was a witness to the seizure list EXT1, whereby the IO had seized a 3 feet long siprang along with handle. And PW1 stated that he subscribed his signature in EXT1 as EXT11. PW1 further stated that he heard about the incident only on the next day. And he heard from the villagers that the accused had murdered his father. But he could not recall the name of the villagers from whom he heard about the incident. When cross-examined, in his cross-examination, PW1 testified that he knew that the deceased used to consume liquor heavily, and after consuming liquor, correct me, more than this is correct, Hidar and Didar,
Yes,
correct?
correct. I think so.
He used to fall, Hidar and Didar. Bold might over HIDER and DIDER. Bold quit over. PW1 admitted that he did not witness the incident. Software. Like PW1, PW2, Bhola Tati is also a co-villager, is also a inhabitant of village Polas Bosti. Where the disease and the accused used to reside. Post of PW2 reports to the effect that he came to know about the incident only in the morning on the following day. And he heard that the accused assaulted his father with a siprang. And as a result, the deceased succumbed to the injuries. Full stop. During cross-examination, PW2 admitted that.
Cautious spelling HITHER and PHITHER.
Ether and ether. He PW2 further stated that he came to know later on that at around 5:30 p.m. on 11/4/2016, the accused assaulted the deceased with a siprang on his back after seeing that the deceased touched the private parts. Full stop. Para. PW3, Thuma Orang is another resident of village Polas Bosti. Full stop. In his testimony, PW3 stated that he heard that the accused had killed his father. Full stop. He further stated that one siprang which was seized by the seizure list, EXT1 in his presence by the IO. He gave his signature as EXT12. Full stop. PW3 further stated that inquest proceeding. In the inquest report, EXT2, he gave his signature and he identified his signature therein as EXT21. Full stop. In his cross-examination, PW3, like PW1, deposed that the deceased used to consume liquor heavily, and after consuming liquor, he used to fall hither and thither, hither and thither. Full stop. Para. Para না লাগে। এইটো আৰু এইটো দূৰত দি দিয়ক আৰু সেইখিনি দিয়ক এই পানীটো পৰিব নহ'লে চাওঁ এইটো গুচাই দিয়ক We find that The prosecution witnesses PW1, PW2, and PW3 did not depose anything as regards anything as and did not depose anything as to how and when the incident of assault had occurred. Full stop. They came to the place of occurrence only after the incident was over. Full stop. Therefore, comma, and they and full stop. These three prosecution witnesses had deposed that they were informed, they had learned from other persons that the accused had assaulted the deceased with a Cipran. Full stop. Such part of their testimonies are not of any assistance to the case of the petitioner, as the same would only be hearsay evidence. Full stop. So even except well, so insofar full stop, that would not, however, affect the testimonies of these witnesses as regards the seizure of the Cipran from the PO and holding of the inquest proceeding. Before discussing the testimonies of at this stage, comma, it appears necessary to discuss, to dilate about the manner how a contradiction can be brought on record. বলবে ভালো না তেতিয়াহলে এটা ডিসকার্ড কৰিব পাৰি The statements recorded under section 161 CRPC by the IO during the investigation are not substantive pieces of evidence. Full stop. Section 162 CRPC. Bars use of police statements except for the limited purpose of contradiction of such bars use of statements of witnesses recorded by police except for the limited purpose of contradiction of such witnesses. Full stop. The statement made by witness before the police under section 161 CRPC can be used only for the purpose of contradicting such witness on what he has stated at a trial as laid down in the proviso to section 162 within bracket 1 CRPC. Full stop. Such police statement can be used primarily for a limited purpose. Roman 1. Para 16 was it, and Pekin is short. 1. Of contradicting such witness by an accused under section 145 of the Evidence Act. Roman 2. The contradiction of such witnesses also by the prosecution, but with the leave of the court. And Roman 3. The re-examination of the witness if necessary. Full stop. Section under section 145. No. As per section 145 Evidence Act. Section applicable. It is when it is intended to contradict the credibility of a witness can be impeached by proof of any statement which is inconsistent with any part of his evidence in court. Evidence sequence. As per subsection 3 of section 155 of the Evidence Act, the credit of a witness may be impeached by the adverse party by proof of the former statement of the witness which is inconsistent with any part of his evidence, which is liable to be contradicted. Full stop. It is provided in the first limb of section 145 that a witness may be cross-examined as to the previous statement made by him without such writing being shown to him. Full stop. But the second limb provides that, quote, if it is intended to contradict him by the writing, his attention must, comma, before the writing can be proved, comma, be called to those parts of it which are to be used for the purpose of contradicting him, unquote. Full stop. There is thus a distinction between the two limbs, comma, two limbs, full stop. The first limb does not envisage impeaching of the credit of a witness, and it only enables the adverse party to cross-examine the witness with reference to the previous statement made by him. Full stop. The adverse party may at that stage succeed in eliciting materials to his benefit through such cross-examination, even without resorting to the procedure laid down in the second limb. Full stop. But if the witness disowns having made any statement which is inconsistent with the present stand, comma, his testimony in court on that score would not be vitiated until the cross-examiner proceeds to comply with the procedure prescribed in the second limb of section 145. Full stop. The Honorable Supreme Court in VK Mishra and another versus State of Uttarakhand and another, report in 2015 9 SSC 588, comma, has succinctly explained the manner in which a contradiction should be brought on record, shall be brought on record. Full stop. For ready reference, comma, the relevant excerpts from VK Mishra Supra are extracted herein below, paragraph 19 also. Para. If the defense has been able to brought the contradiction on record of on record in respect of a witness, comma, in the manner indicated above, comma, then the credit of such witness stands impeached with that part of his evidence given before the court. 155. Full stop. When we turn to the testimonies of the prosecution witness, PW4 Mohammad Abul Hasim and PW5, Fajr Ali Ahmed. We find that other than a part of their testimonies relating to testimony is given in chief, given in examination chief, relating to their witnessing the inquest proceeding given in respect of witnessing the inquest proceeding by PW4 and witnessing the seizure of the CIPRAM. A measured part of the testimonies of both these witnesses were marked by the defense and thereafter confronted them they were confronted. So on being so confronted, both PW4 and PW5, during their cross-examination, denied to have not made such statements, denied to have, denied denied that they denied that they denied that they did not make such statements before police, marked by the defense. Full stop. When the defense had thereafter confronted the accused, confronted the IO, no? IO. When he was examined as nine, by drawing his attention to the statements marked for the purpose of contradiction. Full stop. When the IO PW9 was so confronted, he stated that the prosecution witnesses PW4 and PW5 did not state before him in the manner shown, marked, full stop. As the prosecution, as the defense has been able to bring the contradiction to in respect of a major part of the testimonies of PW4 and PW5, the credit of these two witnesses stood impeached to that extent. Full stop. The prosecution case has mainly hinged on the evidence of PW5, Parvati Munda, the daughter-in-law of the accused and the wife of the, daughter-in-law of the deceased and the wife of the accused. Full stop. In her examination in chief, PW7, deposing on the incident, had stated that the occurrence took place at about 3:40 p.m. on a day, on the relevant date, full stop. At the time, comma, she was in her house sleeping. Full stop. But her father-in-law, comma, that is the deceased, entering into the house, drew her clothes when she was asleep. Full stop. Of the disease, comma, her husband, by means of a siprang, assaulted his father and inflicted an injury. Full stop. As a result of the injury, P 7 deposed that as a result of the injury, comma, her father-in-law died. Full stop. Then she went to her parents' house for some time. Full stop. When she, PW 7 further stated that when she returned after some time from her parents' house, comma, she saw the dead body of her father-in-law. PW 7 further stated that during investigation, comma, the police seized the siprang by which the accused, that is, comma, her husband, assaulted the deceased, comma, that is, her father-in-law. So PW 7 further stated that the siprang was produced by her. Full stop. Later on, comma, Abdul Hasim. Filed a FIR before the police station. Either witnessing to the seizure list, or PW 4 or 5, and filing of the FIR. Filing of the FIR. এই তিনটা একেলগে থাকিব, ইনকুৱেষ্ট, ফাইলিং আৰু সিজাৰ, PW 4 and 5. During her cross-examination, comma, PW 7 revealed that at the relevant time of the incident, both her husband and her father-in-law were in their house. Full stop. PW 7 further stated that when her father-in-law drew her clothes, her neighbors, and she was not aware as to what happened in between her husband and the father-in-law. Full stop. PW 7 also stated that her father-in-law had consumed excessive liquor on the date of the incident and claimed ignorance when questioned, that the claimed ignorance about sustaining the injury her father-in-law by her father-in-law on falling due to intoxication. Full stop. Para. From the testimony of PW7, naলাগে, para. PW6, Biren Munda, who was a nephew of the disease. Who is a nephew of the disease and also a neighbor, an inhabitant of village Polas Bosti. Deposed that at about 3/4 p.m. on the date of the incident, he met his uncle, within bracket Bordeuta, Sanika Munda, as his uncle was lying on the road. Full stop. Finding him in such condition, PW finding his uncle in such condition. Finding his uncle, Sanika Munda in such condition. He, PW6, stated to have taken his uncle Sanika Munda to his house, PW6 house first. Poster. PW6 further stated that thereafter, he took his uncle Sanika Munda to his house, to his house, the disease, to the house of the disease, to the house of his uncle Sanika Munda. Full stop. It was in the evening on that day, his uncle Sanika Munda died in the house of Jugen Munda, that is the accused. Full stop. In his testimony, PW6 stated that he came to learn about that a quarrel took place in between his uncle, Sanika Munda and the accused, Jugen Munda. Full stop. PW6 was cross-examined by the prosecution after permission by the learned, after taking permission from the court to declare him as hostile. First off, when PW6 was cross-examined by the prosecution, PW6 denied that he stated to police that page 22 quote Neelam Agnishu. Due to assault of Jugen Munda, his father Sonika Munda died. Full stop. When the IO PW9 was thereafter confronted with a marked with the said mark part. During his deposition in chief, and the IO stated that PW6 stated before him that page 29 Nila, quote unquote. Due to assault of Jogen Munda, his father Sonika Munda died. Full stop. In his cross-examination, PW6 stated that his uncle Sonika Munda was aged about 85 years of age, and he used to consume excessive liquor. Full stop. He denied having stated before the IO that Jugan Munda assaulted Sonika Munda. When he was examined by the defense. Full stop. From a combined, from on evaluation of the evidence of the prosecution witnesses, PW6 and PW7, we find that there is no inconsistency in their evidence as regards the occurrence, as regards the sequence of events leading to the death of the deceased. Full stop. From the testimony of PW6, in his testimony, PW6 stated that at about 3/4 p.m. he met his uncle Bordeuta, Sonika Munda, within bracket deceased, on the road, in a road, and the deceased was found lying on the road at that time. Full stop. Finding him in such condition, the deceased was taken to the house of PW6 at first, and thereafter, to the house of the deceased comma, which is also where the accused, where his son, within bracket the accused, and his daughter-in-law, within bracket PW7, also used to reside. Full stop. When the deceased was taken to the house, comma, he was in an intoxicated condition after consuming excessive liquor. Full stop. From the testimony of PW7, it has emerged that the deceased had committed an act of transgression by entering into the room where his daughter-in-law, PW7, was sleeping at around that time and drew her clothes, comma, as mentioned in the charge sheet by the IO. No, like full stop, as mentioned. Like the said act of the deceased was seen, was witnessed by the accused, comma, who was also in the house at that point of time, comma, as testified by his wife, comma, PW7. Full stop. On witnessing the incident, comma, on witnessing such act, comma, such act on the part of the deceased, on the part of his father, on his daughter-in-law, comma, the accused, who is the son of the deceased, comma, assaulted his father, the deceased, by means of a cipran. Full stop. As a result of the assault, comma, the deceased sustained an injury full stop. As testified by PW7, comma, the deceased succumbed to such injury caused by the accused by the cipran. Full stop. When police visited the place of occurrence, comma, that is the house of the accused and the deceased, comma, it was PW7 who handed over the cipran to the police, who, comma, in turn, comma, to the IO, PW9, comma, who in turn, comma, seized the said cipran by way of the seizure list EXT 1. Push. Fair. Full stop. So it is uh, we find that when the IO PW9 laid submitted the charge sheet, comma, it was indicated that the accused assaulted his father on his chest and back with a handle of a siprang that was lying nearby. Full stop. Para. The section 122. Point on, sole witness question. Hey, PW 6. PW 6. PW 6 na 7? 6. The prosecution witness PW 6 in respect, so insofar as insofar as the prosecution witness, comma PW 6 is concerned, comma the prosecution took permission from the court to confront him with a limited part of his previous statement. Full stop. Such cross-examination of PW 6 qua a limited part of his previous statement does not make him an unreliable witness so as to exclude his entire evidence from consideration altogether. Full stop. The law is settled that the evidence of an witness who was cross-examined to a limited extent by the party who called him as a witness, comma, can be relied upon, who was called by the prosecution, can be relied upon to the extent to which he supports the prosecution version and it remains admissible in the trial and there is no legal bar to base conviction upon his testimony if corroborated by other reliable evidence. Full stop. But as per section 134 of the Evidence Act, no particular number of witnesses shall in any case be required for the proof of any fact. Full stop. The law is settled that reliance can be based on the solitary statement of a witness if the court comes to the conclusion that the said statement is the true and correct version of the case of the prosecution. Full stop. Thus, conviction can be based on the sole testimony of a solitary eyewitness. But in order to be the basis of conviction, his or her presence at the place of occurrence has to be natural, and his or her testimony should be strong, reliable, and credible, and free from any blemish. Full stop. Monday. Very difficult. We have one single bench.
Monday, your lordship takes another matter, yesterday's one.
Which one? We'll complete this one.
Fine.
If required, we'll spill over that matter. No. Hello? I sleep with you. Huh? Did you have the- No, sorry. My sleep good with you. And Mr. Ecolita and Michael Security for the appellant and Mr. MS B. Punya, Senior Counsel and Additional Public Prosecutor for the respondent state. As the hearing has remained inconclusive, lays the case as part heard on Suez. Sorry, basically.
2012, my lord. Prior to the filing of this writ petition, my lord, earlier also one advertisement was issued in the year 2015. He approached this honorable court with regard to A's condemnation. That petition initially was considered with regard to an interim. He was directed to appear, but later on merit it was rejected, and subsequently writ appeal was also rejected. While observing the writ petition in the earlier rejection, there was one of the reasons that no specific reasons with regard to condonation of upper age limit to consider certain specific conditions must be there. There was an observation, my lord. My lord, here the advertisement was again issued. My lord, the fresh advertisement is issued in the year 2024 with regard to the filling of the post again, my lord. The petitioner before your lordship has been serving since 2012, like more than 12 years of service, my lord, as a casual employee in that post, my lord. My lord, here this petition is filed with regard to the condonation of, my lord, the upper age limit of the petitioner to consider him to appear before, to participate in the process, my lord. My lord, here the rejection list of the, my lord, the rejection list with regard to the petitioner I have annexed at page 60, my lord.
Page
60, my lord. Annexure 22, page 60, which I've collected from the website, my lord. Page annexure 22, page 60, my lord. At the first is the petitioner. At the right hand corner, it is written, age of the applicant is not as per the criteria of the advertisement dated 1/6/2024, my lord. My lord, he is presently 51 years, 5 days. But my lord, today, after filing of this writ petition, while going through the website of the Kasar Silchar, my lord, today morning I have collected from the website itself That I couldn't enter because I was not aware that this was there, my lord. Today morning at serial number 63, my lord, I have seen with regard to the same advertisement, one person was accepted. His age is 45 years, 1 month, my lord. I've seen, my lord. Then with that regard, today morning from 2015 till 2024, we have said in the writ petition of the High Court Service whether any writ petition has been filed this person for condoning his age limit or of any such order, but no such petition is also pending with regard to this said person, my lord. So, my lord, I'm not aware whether how this with regard to the same advertisement, the another person was considered. With regard to the petitioner,
We don't know about
Yes.
the reason behind his
Yes.
condemnation, but so far
my lord,
your is concerned, it is 51 years.
my lord, I have
He is
been,
on the verge of retirement.
my lord, this with this.
What?
My lord, with regard to the same vacant post, you have been serving for, my lord, 12
No.
years, my lord.
Casual post
My lord,
or
casual, because there
whatever.
was initially, my lord, my lord, the post was when there was no driver. He was, then he was the bungalow peon. He was made
No,
advertise.
tell me you, under the provision of law, whether this kind of ineligibility
My lord,
qua the advertisement is permissible.
my lord, that I know, my lord,
Then if it is not
my lord,
as per law,
yes, but
so far advertisement is concerned, one cannot go beyond the advertisement.
my lord.
And I think advertisement is saying, I think,
Page 54.
Page 54. my
page
lord.
54,
It says about 40 years, my lord,
40 years.
my lord.
Then upper age limit relax only SC, ST, OBC.
My lord.
This man belongs
No,
to general.
General category. my lord.
Then where is the question of condemnation under what provision of law?
My lord, yes, my
What
lord,
provision of law? Even if you are casual serving for many years,
my lord,
but you have to meet the eligibility criteria,
my lord,
qualification, age, everything.
my lord. My lord, here, my lord, there are instances of this honorable court on many
We
occasions.
don't know about the instance.
My lord, for appearance, my lord,
Huh?
considering
For appearing when
to participate in the process, my lord, that is.
what participate in a process to do, you cannot ask the court to commit illegality.
My lord.
We don't find anything, yes.
Otherwise also, the educational qualification is also
We have
not
no,
matching.
we have no objection in your continuing as casual.
My
So
lord.
for participation in a recruitment process,
My lord,
it has to be by as per the eligibility criteria
my lord,
laid down in the advertisement and laid down the rules.
my lord, my lord,
If the advertisement is not in consonant with the rules
my lord,
and rule permits
my lord,
participation of a 51 years of age candidate,
my lord.
then advertisement will be not in accordance with the rules. But I don't think
My
rule
lord, there is no
permits.
infirmity in that, my lord.
Apart from that, the issue regarding age relaxation has already been decided in the previous round of litigation by this honorable court. So perhaps the
Very.
res judicata will
No,
come.
my lord, in that
Page
petition,
46, my lord. Same
Page-
issue. There was also an advertisement and he
1 minute. Heard Mr. BC Das. This petitioner
this
This
petitioner,
petitioner.
my lord, this petitioner,
so this honorable court dismissed the writ petition.
responded to another MS City inviting application for which such are the eligible criteria. There are also requirement must not be less than spans of 38. Age and limit. Last date of making application was based on 36. At the relevant time, he was working as casual typer. Purely on temporary basis. Date of birth, his age, 41. Therefore, having regard to his criteria mentioned here. Application to residents or seeking his resolution product or registration. The registration was informed about the rejection. Application of the state communication came to be accepted and reviewed seeking passing the state communication fair was made to allow the resident participants following the advertisement because of the issue, nothing in the same and intent by the member does. Just to the same to allow the group to appear in the
Yes, my lord. Because my,
Then
that,
it was
that,
carried
that
to
was,
read appeal. Read appeal also.
Read appeal, I have read the read appeal.
Yes,
Yes,
yes.
my lord,
Order.
that is the reason I have
So-
apprised this honorable court prior to my submission proceeding, because in that just once order was that no compelling or special reasons has been made out by the petitioner for relaxation of his age. Here, my lord, the only thing that is why I have apprised this honorable court before proceeding, that only on one ground I am filing this writ petition, that since I have continued for 12 years and my
That at that
Yes,
time
my-
also, you were a casual
Around three-
driver.
I was for 3 years. On 2015, the advertisement was, I was as casual in 2012. That advertisement of 2015, my lord.
That
I appeared in that interview. I was in the
you
first.
stood
position.
first also.
I first.
You were the most eligible one also, but
Yes, my lord, the age, yes.
age,
Yes, my lord.
the same
Yes, my lord.
will apply.
Yes, my lord.
No way.
My lord, no.
We can only issue notice rejecting the interim prayer, which will make this,
Later
Read
on, it will be
petition?
structures only.
you can prefer appeal against declining the interim order. And only we can do that much
My lord. My lord can keep.
in the face of such
Yes. My lord,
overwhelming.
yes, my lord can, one submission, my lord, I was prepared for a dismissal from the morning itself, to be very fair, even as, my lord. But my lord, for one reason, my lord, if issues notice, to be very fair enough, my lord, in between, I can collect this person so that. at
Okay, only,
in the-
but so far your interim prayer you have to
My lord,
reject.
yes, my lord, that,
Third, MS S.G. Borua, Learned Counsel for the petition, and Mr. H.K. Das, Learned Standing Counsel, Guwahati High Court, for the respond number 2
yeah.
4 and
and 5. Poster.
5.
The petitioner has averred that he has been serving he was engaged as a bungalow peon Annexure 3. By an office order dated 30/6/2012, within bracket Annexure 3, with effect from 30/6/2012. In the residence of the member Motor Accident Claims Tribunal, Kachar, Silchar, with effect from 1/7/2012. Purely on temporary basis at a fixed pay of rupees 4,500. And later on, comma, by an office order dated 7/12/2022. He was appointed as a casual driver, comma, as a stopgap measure, purely on temporary basis, with effect from 1/12/2012 until further orders at the same fixed pay of rupees 4,500 in the Office of the Motor Accident Claims Tribunal, Kachar, Silchar, Assam. Full stop. The petitioner has averred that he has been continuing as such till date. Full stop. The petitioner has stated that the cause of action to file the present writ petition has arisen when his application for application submitted in response to an advertisement dated 1/6/2024, Annexure 19. Has been rejected,
My lord, we do
has
not
been
have-
has been placed in the rejected list of candidates, showing the ground that the age of the applicant is not as per criteria laid down in the said advertisement.
But educational qualification is also educational qualification. HSLC not there.
Post op. MS Borua. MS Borua, Learned Counsel for the petition, has submitted that she has received a copy of the accepted list of candidates for the same post of driver today morning, wherefrom it is revealed that another candidate named Shekhar Shukla Vaidya, whose age was also beyond the age criteria laid down in the advertisement dated 1/6/2024, has been included in the has been accepted, and projecting so, has sought for a similar relief. Post of Mr. Das, Learned Standing Counsel GHE. By referring to the earlier instance of rejection of candidature of the petition on similar ground, has submitted that the prayer of the petitioner is not merited. Post of issue notice returnable in 4 weeks. As Mr. Das, Line Standing of the GSC, has appeared and accepted notice on behalf of the respondent number 1, 4, and 5.
2, 4, and 5 million.
2, 4, and 5. Formal issuance of formal notice to the said respondents stand dispensed with. Extra copy, requisite number, 3 working days. The Learned Counsel for the petitioner shall serve requisite number of copies of the writ petition along with annexure to the senior government advocate Assam for service of notice upon the respondent number 1 and the respondent number 3 within 3 working days from today. Post heard the learned counsel for the parties also on the interim period. Full stop. From the case record, from the case papers, it has emerged that on an earlier occasion, the office of the Motor Accident Claims Tribunal, Kachar Silchar, published an advertisement on 26/5/2015 for filling up a vacancy in the post of driver. Full stop. The petitioner, who was working as a casual driver at that point of time also, submitted his candidature in response to the said advertisement. Full stop. The advertisement dated 26/5/2015 required that a candidate must not be less than 18 years and must not be above 38 years of age on 1/1/2015. Full stop. As the date of the petitioner, date of birth of the petitioner is 26/5/1973, and his age on 1/1/2015 was 1 year, 6 months, 6 days, the candidature of the petitioner was rejected initially. Rejected. Full stop. Agreed thereby, the petitioner preferred a writ petition before this court. Preferred a writ petition. WPC number 5587/2015 before this court. Initially, an interim order was passed allowing the petitioner to participate in the selection process. Full stop. But later on, the writ petition WPC number so and so came to be dismissed on merits. Full stop. When an intra-court appeal was preferred by the petitioner, intra-court appeal, writ appeal number 180/2018 was preferred by the petitioner, the same was also dismissed on 28/2018. Full stop. Finding no merits in the writ appeal. Full stop. The advertisement dated 1/6/2024 has prescribed that a candidate should not be less than 18 years of age and not more than 40 years of age as on 1/6/2024. And upper age limit is relaxable only in respect of candidates belonging to SC, ST, OBC. Full stop. The petitioner, admittedly, the petitioner belongs to an unreserved category. Full stop. And his date of birth is 26/5/2000.
1973.
1973. Full stop. After scrutiny of the application of the petitioner, which was submitted in response to the advertisement dated 1/6/2024, comma. The office of the respondent number four has it appears that has rejected the candidature of the applicant as he is found to be 50 found to be aged about 51 years 5 days as on 1/6/24. Full stop. The advertisement also required that a candidate the minimum has also prescribed that the minimum educational qualification is HSLC from a recognized board. Full stop. As per in the rejection list of candidates, comma, it is shown that the petitioner does not have the qualification of HSLC. Full stop. Having regard to the above, comma, I find no privacy ground to pass any interim order, as the interim relief sought in this petition is for staying the selection process for filling up the post of driver in the office of the motor accident claims tribunal, Kachar. So you want stay, whereas your prayer should be at least part. Let me participate. You want stay of the whole process.
Yes, participation is my main prayer. Actually, the whole is a
Interim prayer is that stay of the whole process.
My lord, the rejection list by respondent number 5, not 4, the selection board.
Huh?
The rejection respondent number 5, not 4, the selection board. Page 60.
By the office of the by the selection.
Respondent number 5.
Respondent of 5 and 6 could you
Hmm.
5 and 6 could you 4 and 5 could you 4 and 5. 4 and